our order for mediation. Did the court want to address the other issues as far as consolidating the case and then the jurisdictional $25,000 issue?
I think my thought, quite frankly, was we were going to get it to mediation. Those issues were going to case people versus Alec Jerome. Eric Cassidy. State your appearances, please.
Donna Tope on behalf of Caroline Jerome, who's via Zoom,
Yes.
and Alec Jerome, the plaintiffs in our case.
We have Francina Parker with defendant Eric Cassidy. Cassidy's not today.
Okay. I thought that the parties were going to come back today with an indication of a framework for mediation through the University of Michigan Housing, whoever it was. And there was going to be timeframes and the like. Not what I got.
No. So,
and we've already done some work to find out and would accommodate our needs.
so you're hearing both our complaint, which is case number 241C1772, and also their counter complaint that is an earlier case. And the thing that I want to know, would like to know first is, you mentioned consolidation. Would that happen?
No. Hold on. What I said is, both of these files are going to come out to me. Whether it be a formal consolidation or not, as long as it remains in this court, I'm it. So, I mean, whether I work out of two files or one, hey.
Okay. Well, so I guess my question is one of procedure. Do you hear their complaint first, their counter complaint, or do you hear our complaint second or first?
Why does that matter for you?
Because I filed a motion for my case.
Let me just shortcut this. I'm going to hear, if I have both files before me, I'm going to hear whatever needs to be heard in an order that makes sense to me.
Okay.
That's how that's going to work.
Okay. So I also filed a statement on mediation.
Oh, I got it.
Okay. So I also contacted the University of Michigan Mediation Services, and I had a very good long talk with my clients who attended the last hearing. And that statement on mediation is what we have come up with. We would like our complaint to be heard as a landlord-tenant complaint for non-payment of rent and termination of tenancy because they have not paid any rent and they have not paid any utilities.
Okay, I get each party has their claims,
Okay.
but are you agreeing, the contract indicates that it will be mediated.
The contract indicates that either party can request mediation, but they did not do that before they withheld rent.
Does it say that they have to do it before they withhold rent? That's not what I read.
You gave me a really wonderful, precise, and pointed statement on good faith. We are convinced that any mediation would not be met with good faith based on all of the interactions that have occurred during the entire time that this situation has existed.
Let me stop you. They request mediation, which I think they have. And as I read the contract, when either party requested, it should happen. What would you, after you get finished saying everything that you're going to say, what do you want me to do?
I would like you to hear my motion.
So what you want me to do is ignore the contractual language of the lease and just do it your way?
I think they ignored the contractual language of the lease. They contacted an attorney and the attorney represented them, Paula, and them at our hearings.
Are you talking about Mr. Navarre?
Mr. Doug Lewis.
No, Mr.
Doug,
Lewis.
okay. And
that, to me, was that they were not following the language of the
okay,
lease.
so hold on a second. I don't even know why I'm going through this, because do you want me just to order mediation? Because I'll just order it. And then we don't have to go through all of it. I thought the parties, when we left here the last time, I thought the parties were going to look into the process of mediation because we were looking at, you wanted something quick. And I think Ms. Navarre said that she would contact and they were going to figure out how fast they could get it. And that's what we were going to come back for. I set this basically as a check to make sure it just didn't linger out there and try to develop a time frame for how this would occur. That's why that's where I thought we were. And then I get this statement basically saying you don't want to go to mediation. And that doesn't make any sense to me because the contract says that. I think both parties agreed that.
Well, I think they voided that part of the contract when they went to an attorney.
My goodness. When they went to an attorney?
They got an attorney. They did not go to mediation. They did not request mediation. I did not request mediation. Either party could request mediation. They did not request it. They hired an attorney and bypassed it. So yeah, if you order mediation, we will definitely comply.
Well, here's what's going to really
happen.
happen. Here's what's really going to happen. If I order mediation, I'll order mediation. Otherwise, what's going to ultimately end up happening once everything's in place, you're going to be in mediation with me, which is just mediation with a hammer. So it's going to happen one way or another. But I guess my issue was I thought that's where we were. And that's now not where you guys are.
Well, we haven't really
You're on the
consulted.
there.
No, I know. When I said you guys, I was not including you. I was not including that side of the room. I'm sorry. Why don't you want to go to mediation?
We have serious reservations about all of the things that have been said to you during the beginning of this.
Okay, everybody has said all kinds of things.
That we're going to be met with good faith. We have serious doubts about that.
Okay. You have serious doubts about that? I'm sure Harris will have serious doubts about that. I gave my admonishment, thinking to both parties, but also based upon what I had already seen here. I gave my admonishment that all the parties should be acting in good faith. Plain and simple.
And I did tell you that clause is written in our lease because before anybody goes to an attorney, if there are issues, both parties.
Does it say that?
It does say that in the lease. Before what? Before the issues are under litigation. It says.
Okay. The fact that somebody goes to an attorney doesn't mean it's in litigation.
Oh yeah, because he appeared at the hearing on my summons and complaint. So that and we were then sent to you. The lease says, and it's on 37 or 34, no. It says, a mediator can't, if communication between tenants and landlord breaks down. There was no communication. He told me the night before rent was due, he was withholding rent, and he withheld rent since then. And before, if communication between tenants and landlord break down, a mediator can assist the parties in voluntarily reaching a mutually acceptable settlement of the issues in dispute. There were no issues in dispute. We had no knowledge of why he was withholding rent. He just said, we're withholding rent. And he said his wife had retained an attorney.
What is your reluctance to go to mediation?
Oh my gosh, because they have withheld all of the rent. In landlord-tenant cases, only the most catastrophic situation allows for that.
That's not true.
Well, that's what.
That's just not true. Oh my gosh. I mean, no, don't say, oh my gosh. You say, oh my gosh, one more time, I'm gonna find you in contempt, and then
Okay,
we're gonna
I'm
really
sorry.
have a problem. Because that's disrespect.
I mean no disrespect. I'm really saying, oh my gosh, to myself. I'm sorry. I did not intend it for you.
So, look, I don't, here's what I don't get, okay? Just from a practical sense. If you go to mediation and the parties with a mediator try to work out whatever the issues are, right? If it doesn't work, you're here. But the issues typically, when cases are sent to mediation, the issues that are involved get narrowed and they get clarified. And that's where then, when it comes back to the court kind of enters into it, and it's much clearer of what you're dealing with. So there's some benefit to it, or can be some benefit. If you're looking for some expedited process, I don't think that's going to happen. I'm looking at this file. It's not going to move. The period of mediation is not going to make this file move any faster here. If that's what you're looking for.
No, we're not. What we're looking for is some kind of financial certainty that you had mentioned escrow, and my motion is to escrow the amount in arrearage. I know you said that you are capped for $25,000 in landlord-tenant cases, but I'm wondering if the arrearage is more than $25,000.
Well,
are you able to?
If you're talking
that amount?
I'm not going to even answer that question. I mean, I'm not capped at the $25,000 limitation is really on the money judgment. On the possessory judgment, it could be whatever number. But in terms of a money judgment, that's where the limitation goes in.
Okay, well, I don't know the fine points, and so I was asking if we, in our motion, we ask that the arrearages be escrowed, and if that happens, we would
Okay, so first of all,
participate in mediation.
no. I don't know how you think. I don't know what you're negotiating against. I mean, I just don't. You're negotiating saying, well, they got to do X before we're going to do Y.
Well, if it's held in escrow pending the pendency of the case, and we go through mediation and we come to some kind of an agreement, then what was escrowed would pay whatever we come up with in mediation, which could be something less, and they would get the rest. But how do we just keep adding the arrearages on? This was, 20, close to $30,000 over $32,000 of unpaid utilities. How can unpaid utilities be mediated? No, they use them. They lived in the house. They've enjoyed the heat. They've
And
enjoyed
I
the
don't,
electricity.
you're asking me a hypothetical, I can't answer that.
Well, I
You
get,
know,
yeah.
There's no way for me to answer that. Certain things can be mediated. Certain things I think that maybe shouldn't or can't be mediated, they happen to be mediated and have success. I mean, I don't know.
And so we go into June, June 1st is coming up.
How much is monthly
They
rent?
pay nothing.
A month?
Yeah.
Well, ma'am, first of all, council, when you say they pay nothing,
No,
it's not entirely true. If you are requesting an escrow order, I will consider that,
okay.
but not with an escrow order that's in compliance absent certain circumstances, because you're asking me to go back and tell them to put money into escrow. Usually escrow orders, except under the most extreme circumstances, are prospective.
Which they probably should have done instead of withholding all the rent. If they had problems, they should have done that. But
I should have stayed in bed today. I can tell you, they can say you should have done anything. I don't know what you want me to do with that, about what they should have done.
I don't, I'm, Your Honor, I'm thinking out loud, and you have been very good. You have been very patient and with your comments that all contain a nugget of information for me when you are telling me that I'm not making any sense and that this isn't, I thought we had it all set.
So that's getting across?
Some
Okay.
things are, yes, it
Okay,
definitely
okay.
is, but so that's what I'm thinking out loud about is the small little crumbs that you have put out that I am trying to follow
Okay, so let me
to
ask
the
you this.
cottage.
Yeah. If I order escrow beginning June 1st, will you go to mediation?
Oh, yes, absolutely. We are
Okay.
so worried about the finances.
Right, everybody's worried about their finances. But she has her hand up. Your client wants to say
Oh.
something. I don't know.
Your Honor, just to say, the reason after speaking to my brother, we resisted mediation is because we had this house, we're very new. This is our first house we've ever rented. And Donna is very by the books, and she insisted that we do everything, and we worked and we got it ready, and we had it inspected. We had it inspected twice and it passed. So when the tenants suddenly started withholding rent and very unclear as to why, then it was a lot of money and it didn't really build the trust between us for mediation. So I think I don't need you to do anything. I just wanted to state that. I don't need to interrupt the court. You guys know what you're doing. But I just wanted to say that that breach in trust has really affected this investment that
No, I got you, but
okay.
ma'am, I'll just tell you, part of the reason I have to do this every day is because there's a break in trust between people. So I get it.
Yes.
Okay. So I mean, I get it for various reasons.
All right. I just wanted to say that. Thank you for hearing me.
Thank you for listening.
All right. Ms. Novar, what would you like to tell?
I don't even know where to begin, Your Honor. In addressing the mediation issue, you have been fully informed, but I hear the court going in the direction of ordering mediation, which is what we want. In August 31st of 2021, my client emailed and told the landlord they were withholding rent due to no effects. that's in writing. And they told the landlord that they were hiring others. They've got things not working from day one. Et cetera. Air conditioning is not working.
Your Honor,
So why are you interrupting?
because you did not allow me to address those same things
but
the last
hold
time
it,
you
Ms.
brought
Jones.
them up.
But hang on. You expect me to have Ms. Novar, she sat there patiently saying nothing while you went on about mediation. Particularly, it seems to me that what she's addressing right now is your, I'll call it an accusation, that they didn't tell you anything and that's why mediation shouldn't happen. I think that's the issue she's addressing. She's saying, look, they told them, and this is what they were talking about the defects.
His email to me said, we are withholding rent, period.
Your Honor, it's our exhibit 4. It doesn't.
I know.
It doesn't say that. Your Honor,
Yes.
this is the strangest case I think I've ever been part of.
Well, you should come to my world sometime. But go ahead.
The point of the matter is that our clients withheld rent. They told them why they were withholding rent. Those still issued, and then they paid it in December. They had a family a very tragic event occurring with his wife, one of the tenants. So they had to go to Houston for treatment and surgery. And so they just said, we're gonna pay it. Let's hope when we get back, these things are taken care of. When they got back, not only were the things not taken care of, but now we have a mice infestation. They refused to do anything about the mice infestation. They called Terminex themselves. So they've in good faith. They paid their rent, hoping that they would see change, and they have not seen change. We're still dealing with the same issues they've been dealing since June of 2023. I think it's not number one, and number two, I think it's unreasonable to ask for back rent for the reasons the court, not only that, the court rule doesn't allow it. 4.201 I2 says it should be escrow, future escrow.
And just so that we don't have to worry about that, the only time that I ordered that's why I said it to extreme circumstances, I use what equitable powers this court does have over these cases to order that held. I don't see that here at this point.
So then at this point, I guess we're asking the court, and we have an order proposed pursuant to the lease. We're asking the court to order that the parties mediate. We have found out from University of Michigan, they can call their program now, they're happy to mediate, and they can do so. Very quick order, within a week or two, I think we could probably get in with them.
Within a week, really?
And we asked for mediation way back in September, and then Mr. Cassidy again in writing asked for mediation on January 27th, I believe it was. So we've numerous times have asked. I think their position is once they hire an attorney, it means they don't want to. Which is ridiculous, and the lease doesn't say that.
Yes.
So I would ask the court to enter an order for mediation. Did the court want to address the other issues as far as consolidating the case and then the jurisdictional $25,000 issue?
I think my thought, quite frankly, was we were going to get it to mediation. Those issues were going to kind of be held off, seeing if it could be resolved at this level in mediation. That is how I envisioned when I left last week that this was going to proceed in that fashion. I thought everybody was on board with that. Okay. Is there anything else you wanted to say?
Just that if you allow escrow, prospective escrow, can we at least get an order for the payment for the unpaid utilities, electricity and gas that now are $3,418.78.
Look, folks. All right. I realize that there may be some financial pinches and strains. I get that. But every time I ask a question, I'm not going back to that issue. Just not.
So mediation is going to include the rent, the utilities,
It's going to include all issues.
and the court costs.
It's going to include all issues.
Okay, will you formally, do I prepare an order for you to sign about prospective escrowing?
Oh, it's just called escrowing, but can I see, have you seen the order prepared by Ms. Novak?
No,
My client sent it to me right before court. So
Pardon?
this is just the order for mediation.
this
Yes.
is just the order granting mediation. So, I mean, we will sign this. We also,
No, okay, you need to understand something.
okay,
Well, I don't, I don't know what other courts do entirely, but if I'm gonna order something, I'm gonna order something and I'm gonna order something else, but I'm not doing this, we will agree to this if.
we just need a little certainty
Certainty of what?
somewhere down the road. These people who have been underwriting their residents for,
Look, I have no reason, and that's what I'm talking about. I have no reason to believe that one party isn't gonna do what they're supposed to do or that another party isn't gonna. I don't have any basis for that. And I think I was indicating that to the parties the last time. I'm going to assume that people will act in good faith. It's really as simple as that. And so here's the other thing that I'm going to order. So hopefully we can make us more problem. I'm inclined to sign this order for mediation. All right. Do either of the parties have a time frame they believe for the length of mediation and timing? And what I mean by that is usually when we're sending, this one's going to be unusual, certainly. When we send cases off of the summary proceedings docket, I indicate that mediation should conclude in 45 days. The parties can then, of course, come to me and say, well, we're close to doing whatever. And so can we continue? And then I will make a decision as to whether or not it moves. So that's typically how it works. And so I guess, do either party have a suggestion as to how long the mediation process should last?
I also talked with them, the University of Michigan. It's not on, what is it called? On site, on campus?
Off-campus housing program, which is what's contained in the lease, which is here. It may have some new name,
Right.
as long as it's whatever.
And I was told that, yes, we would be able to be heard within a week or 10 days. I would guess that if we set 3 weeks from today, and then if mediation is going well and we need more time, we can come back and ask for that. Or, come in and present the result of mediation.
All right, here's what I'm gonna do. Parties, I'm gonna sign this, we're gonna do two things. I'm gonna sign the order for mediation. the parties are to cooperate in mediation. I'm gonna add one thing to this order, and that is that mediation to conclude by, and I'm gonna put June 21st, 2024, unless otherwise ordered by the court. So that's the first thing that I'm going to do, and I'm going to sign this order. So now this case is headed to mediation. I'm also going to enter an escrow order. In fairness to the parties, here's what I'm going to do. People can be upset with me if they want. I'm going to order that escrow will start May 15th. Okay. No, May 15th. No, it's okay. If you want to get up here and order, here, you want to. I'm just saying, if you want to do this.
It looks better on you.
So we're
You
going to
look good in
start
black.
escrow May 15th, which is going to then require that plaintiff post 2,000, if monthly rent is 4,000, you need to post 2,000 in the court escrow for the month of May. 4,000 would need to be posted for the month of June and each month thereafter that the matter is proceeding. Make sense? All right.
My question is,
Yes, ma'am.
utilities go month to month. I have given them the utility bills. Will we be able to escrow the utility bills? If they're going to be under mediation going forward, not
All right.
going
Let
back.
me just ask this. Average utility bills per month, what utilities are?
I included the most recent invoice and
Well, I don't. Okay, first question.
$340 was due on
Can you let
May
me get
1st.
my question now? What utilities are we talking about? first of all?
Electricity and gas.
Is that all through DTE?
Your Honor, as I understand it, this is very odd again, the utility, my client's never seen the utility bills.
Oh, I've sent them all. I've sent them all.
He tells me they've requested them and they haven't even seen them.
They were sent with every invoice.
Yeah, I requested them in January, February. It's the first time I've seen them. Yes, I've seen the bills.
Okay.
I've seen cars.
So,
We need to see all the bills.
well, but hold on, folks. Yeah, I mean, and that will at some point happen. But it's just gas and electric.
Yes.
It's all DTE.
Yeah.
Right?
Yes. DTE. There's no water, no sewer.
Okay. So then, are they, who's paying the water?
We, in the lease,
That the landlord's paying the water?
we keep them in our names so there's no transfer fee and to ensure that there's no shutoffs for whatever reason. And then I bill with the rent on a monthly basis,
Bill what?
the amount of the utilities from the past month.
Okay, and so what I'm asking is what utilities are you billing for?
Just DTE and
Okay, listen, just listen to my question.
I
Water, no, just
No.
listen. Water is basically paid for by the landlord.
there is no water bill. We're on a well.
That's all you needed to tell me. You're on a
Okay.
well and septic,
Yeah,
right? So there is no water.
that's what I said. I did say that at the beginning. There's no water and no sewer.
Okay. And apparently I misunderstood. All right. So the only utilities, let's just boil this down, folks. The only
Yes.
utilities are DTE. Everything is, every utility that would need to be paid for by the tenants is DTE. Okay, so. And I don't have a problem escrowing part of, or the utilities. However, what's the average utility?
The average utility bill when they are in residence is about $340. 320, 363. That's the last 3 months. That was ending 4/9 and due 5.
Okay, all right, but here's the thing.
Okay,
And this is gonna be part of what the problem is. I'm assuming these bills go up in the winter.
yes, we do not pay a budget. We pay as they occur. But it's AC. So, the heat in the winter offsets the AC in the summer.
Do you have the utility bill amounts for the last 12 months?
Yes,
Okay. So with those bills, what's the average?
I don't have.
You don't know.
Well,
All
no,
right,
no, no,
so-
I know, I got the total and I can divide by 1, 2.
What's the total? What's the total over the last 12 months?
11 into 2,571. $230, $240 a month, average.
What'd you just do?
I just divided the total.
Give me the total amount that you have right there of what you're saying the
Okay,
bills
the
are.
bills that have been unpaid are $2,571.64.
Okay, great. And that is over how many months?
11.
Give me
$233.79.
$233.79. Okay,
We dispute that. They paid some of them. I don't dispute that number. I would also remind the court, the
Well-
landlord has $7,000 in security deposit.
no, I know, but I'm not even to that. They're not out, so I can't deal with that at this point. Well, hold on. I'll get to that in a minute. Jeez. Okay, I'm not gonna do it this way. I'm not gonna do another divide. I'm just not. So if somebody wants to appeal me on that, they appeal me on it. I'm gonna order that you are going to pay that $233.79 into court escrow for each month. You're gonna pay that full amount for May. Okay, I'm not gonna half that. I just. Okay. So it'd be, for May, it'd be $2,233.70, you said 79 and
Yes.
79 cents. And then for May, it'd be $4,233.79.
I think you mean $233, not 2,000.
No, 2,000 is
No.
the rent for half of
Yeah.
May.
Oh, sorry.
Right, got it.
Okay.
That's what I did.
Yep, yep.
Okay. So that's what we need to be deposited. The rent or the escrow for May, you'll need to do that within 7 days of today. And then for June, it's 7 days from when it's ordinarily due, but it will be due by the 7th of
7th
each
of-
month. Okay? All right. Yes.
Can I ask that you add that this continue monthly until order of the court? So that if we have to go mediation
Okay, the
longer.
way the escrow order works, it continues
Okay.
till this matter concludes
you.
or until I say
Just-
whatever.
Just,
That's the way it works. You understand that, sir?
Yes, I do.
You'd have to continue to pay. If we're here in 2027,
No.
you still gotta pay it.
God,
Okay. Then I'm gonna give a control date on this for the parties to come back. If there's no further requests from mediation, so mediation basically would have to conclude without anything else by June 21st. I'll set this for a hearing June 28th, 2024 at 3 p.m. Yes.
I can't make that. I'm celebrating my 80th birthday up north with my family. And we start on the 27th.
Okay.
So if you make it earlier, that would be all right, because I
Well, I
think,
don't want it earlier because I do it on Fridays.
oh, okay.
And so the 21st, I'm here July 5th. Will July 5th work?
That's the Friday after the 4th. Yeah, I'll be here.
That's why it's the 5th. Yes.
I'll be here.
All right. What time?
I don't have a time yet,
Well, it's the week after, so.
well,
12. July 5th at 12 noon.
Thank you, Your Honor.
Okay, now let me try to address one other thing, and I really want to make more issues than we have. There's a $7,000 security deposit. Why is it 7?
Because they have permission for 2 dogs, and our policy is that we collect a dog security deposit of $500 for each dog. And so the security deposit for the rent is $6,000.
Okay. It might be an issue. Pardon?
They're very nice dogs. I've met them.
Your Honor, we have one other issue that.
Oh, we're-
Can we raise it? You know, it's out.
no, you go right ahead. That's fine.
And what really brought it to our attention was a statement on mediation that Ms. Toth filed. She has really made herself a party to this and a witness to all of these. We are suing her individually for defamation per se. For allegations. We're suing Ms. Toth. She's made police reports, false police reports against my client. And I'm seeing a possible conflict of interest pursuant to attorney ethics that will require her to not represent the Jerome's moving forward because she is a witness and also being personally sued. And so I don't know if the court wants that issue before us at this time, but it's an issue that I was alerted to this morning as I was reviewing for pleadings.
So I wear 2 hats in this situation. I am the landlord's agent in managing the lease. And that situation that I described occurred while I was performing my responsibilities in managing the lease. Once we had to file for, once the plaintiffs decided that they would file for withholding rent, they asked me to represent them as an attorney. So I think in all of the proceedings that are requiring the landlords to be represented by an attorney, the situation that occurred against me personally should have no bearing on my representation of them. That's denying them.
Okay. So the short answer, Ms. November, to your question is, I would like that I won't address that today, but that would have to be raised by a written motion before the court. Giving ample opportunity for Stowe to respond. Counsel, I would, and why I think it would be best that it is in writing. And I'll just say this, and I don't have the answer to it, but I think what Ms. Novar in part is indicating, you both may be talking about the same thing in a lot of ways, because if you're acting in one capacity at one point and something occurs, and then litigation ensues, it may very well be that you are outside of any claim that might be made by the defendants in this case, that you may be a witness to the proceedings, and so may be in a position where you could not proceed forth.
And that, I
So,
understand.
yeah, I don't, like I said, I don't want an answer to
No,
it,
no, I know.
because I'm just saying that's the first thing that, outside of what Mr. Nobar was saying, that's the first thing that came to my mind after you finished saying what you were saying. So it may be right, but I think it's probably better if that be the case, that be put in writing right before the court. And then after you see what their issues may be, ethically, you may think, yeah, they may be right. Let me do X. Or you may say, nope, I don't think they're right. Let the court decide whether or not it can be here or not. That's probably a much better way for us to proceed on that. All right, is there anything else? Seriously? Nothing? Okay. All right. Then-
Wonderful vacation. You said you were gonna have a blast.
Oh, I am.
Does it begin now?
The moment I walk out to my truck. All right. So, all right, folks, you guys have a great holiday and be safe, please. Ms. Novara, could you prepare an escrow order for the court signature? To the court, thank you.
How would I submit that? Should I email it?
Yeah, you can actually email that right to Ms. Whiteling. All right. And it will get to me. Thank you.
Yes, well.
Am I 14 days stands adjourned?